All right, we're on the record now in Beeland versus Beeland, case number 2419895. We have Mr. Blumberg here by Zoom on behalf of Mr. Beeland, who's with him.
Hold up. Did someone just get caught lying to a judge about secret boyfriends and hidden income? Welcome back to Courtroom Chronicles, where we're diving into two explosive cases today that'll make you question everything you thought you knew about divorce court. In our first case, we got accusations of intentional misrepresentation, a mysterious boyfriend who's apparently been arrested, and a desperate fight over who pays a mortgage. Then stick around for case 2, where we'll witness the instant karma of remarriage killing spousal support payments, and one ex-wife's bold attempt to keep the money flowing anyway. These cases are about to get messy, so buckle up because the drama starts now.
We have Ms. Beeland also here by Zoom. This is set for hearing today. Mr. Blumberg, you filed a motion. Your client is asking for relief from ex parte order that was signed by the court, requiring him to pay certain household expenses and so forth at the beginning of the case. Anything you wanted to state by way of oral argument in support of your motion today?
Well, I would just again reiterate to the court what my motion and supporting brief suggests, that the court signed an order based on information that was not accurate. I don't know if there were intentional misrepresentations made, but the net effect of those is that you signed an ex parte order requiring my client to pay certain obligations, when the reality is that when the motion that was filed, it was asserted that she was not working and that she failed to indicate to the court that she had her boyfriend living there, a roommate who was contributing financially to the obligations. Those are certainly material facts that were either omitted carelessly or intentionally.
WHOA, let me break this down for you. An ex parte order means one party went to the judge without the other party present, and apparently Mrs. Bean claimed she was unemployed and struggling alone. But plot twist, she allegedly had a boyfriend living with her helping pay bills. That's what we call material omission in legal terms. And if proven true, it could mean she misled the court to get more money. The attorneys being diplomatic, saying, I don't know if it was intentional, but come on, forgetting to mention a live-in boyfriend paying your bills? That's like forgetting to mention you won a lottery while applying for food stamps. What do you think? Honest mistake or calculated deception?
The bottom line is that I think that had the facts been properly represented to you, you would not have signed such an order. So we're asking the court at this point to rescind that order. My client has been contributing financially, and he's prepared to continue to do so. But certainly, based on the facts that you were presented, I think that ex parte order was inappropriate.
Mr. Blumberg, are there any temporary orders regarding child support in place? Just looking through the file, you might know off the top.
No, there is not.
Okay. And how much is your client contributing monthly at this point?
Okay, he's paying between $150 and $200 a month.
Okay. All right, Ms. Beeland, what's your side of this?
The reason why we decided for Chauncey to pay $600 worth of mortgage, because it is on his name too, along with mine. And during that time that I'm having a hard time understanding this. The reason why we put this, because I was working at a restaurant, barely making a minimum wage, trying to have fully intent of getting my job that is now, I work full-time at Kohl's, just so he could just help pay the mortgage. That's all I was asking. And my boyfriend, he is no longer in the home, but during that time, he was helping pay all the smaller bills, helping me out with that type of stuff.
Okay, so Mrs. Bean just admitted the boyfriend was there and paying bills. That's huge. But notice how she's framing it. She was working, contrary to what the attorney claimed, just making minimum wage at a restaurant, and now has a full-time job at Kohl's. She's saying the boyfriend only helped with smaller bills while she needed help with the $600 mortgage. Here's the critical detail, though. Both their names are on that mortgage. That means if she defaults, it tanks his credit too. This isn't just about fairness. It's about protecting both their financial futures. But wait, it's about to get even more interesting.
And up until he recently left, he was paying and helping me pay all my small bills, and I was paying my mortgage and trying to keep on boat on that. And I have caught up completely on my mortgage so far. It's been hard, but I've been dealing. So I was just asking for help with that. That's all.
All right. Anything in response to that, Mr. Blumberg?
Judge, I don't know that we need to go into the facts why the boyfriend is no longer there. My understanding is he's been arrested and he probably has a no contact provision. But
Hold up. Did this attorney just casually drop that the boyfriend got arrested and has a no contact order? This case just went from divorce drama to potential criminal situation. A no contact order usually means domestic violence or harassment charges. So let me get this straight. Mrs. Bean had a boyfriend helping with bills who's now been arrested and legally can't contact her. She's caught up on the mortgage herself. And Mr. Bean is only paying $150 to $200 a month while the kids are with him half the time? The judge has to sort through this mess and figure out what's fair. Remember, with 50-50 custody, typically neither parent pays the other unless there's a significant income disparity.
But I don't guess that that's really relevant at this point. My client is willing to continue to pay some money to assist, and certainly the kids are with him half the time. So I just, I'm always reluctant when I see these ex parte orders, when facts are presented to the court, and you have no way of knowing whether they're accurate or truthful or not. And I understand it's always best to err on the side of caution, but I genuinely believe that had the facts been properly presented, I don't think you would have signed this order. He'll continue to pay those expenses that he's been paying.
Okay. And Mr. Blumberg, your client is on the mortgage as well, his name?
Yeah. Yes, it is.
All right, so presumably he's got just as much an interest in keeping that mortgage current as Mrs. Phelan does.
Yeah, he does, but he has the expense of another place. Again, when these parties separated, my understanding was that they had an understanding as to how the expenses were going to be shared. That wasn't reflected in any written document, unfortunately. But yes, you're right. He has a monetary interest in that property.
Right. Give me just 1 second. I just want to. All right, is there an amount that we can put on the record here today that your client is willing to contribute per month?
Yeah, my client said he can pay $200 a month.
All right, okay. So I think that's fair during the pendency here, given the circumstances. So Mr. Blumberg, the court is going to modify that order and have it reflect that your client is going to pay $200 per month towards the household expenses.
And there's the ruling. The judge just cut Mr. Bean's obligation from $600 to $200 per month. That is a 67% reduction. This is actually a pretty balanced decision when you think about it. Mrs. Bean admitted she's working full-time now and is caught up on the mortgage herself. Mr. Bean has the kids 50% of the time and is paying for his own place. The $200 contribution recognizes his interest in keeping the mortgage current without overburdening him. But honestly, with both names on that mortgage and kids involved, these two need to figure out a long-term solution. Either sell the house or have one buy out the other. Let's see how case number 2 plays out.
So if you can draft an order that will reflect that and submit that to the court, and we'll go forward from there. Ms. Phelan, do you have any questions about that?
No, I appreciate any of the help I can get. So I just appreciate it. Thank you.
Okay. Mr. Blumberg, anything further on this file today?
No, Judge, thank you.
Okay, thank you. All parties are free to disconnect at this time. Okay. looks like we have both parties connected, so we'll go on the record. This is Van Til versus Van Til, file number 1717089. The record should reflect that both parties are connected by Zoom. This is set for a motion today. Mr. Van Til, you filed a motion to cease spousal support, and your motion is based on the fact that Ms. Van Til remarried at the end of 2024. Is that correct?
Yes.
Okay. Ms. Van Til, is that correct?
Yes.
Okay. Are you contesting the discontinuation of the spousal support?
To an extent, I feel that I was pretty generous back in 2021 when I let him off on over $12,000 in arrearages at the time. I'm willing to drop down to $500 a month for, let's say, another 3 years.
Wait, what? Did she just say she let him off the hook for $122,000 in back support and now wants to keep getting paid after remarrying? This is absolutely wild. In virtually every state, remarriage automatically terminates spousal support. That's Family Law 101. The whole point of alimony is to help a spouse maintain their lifestyle after divorce until they can support themselves or find a new partner. She found a new partner, married them, and still wants her ex to pay $500 a month for 3 more years? That's $18,000 total. I've seen some bold moves in court, but this takes the cake. Let's see how the judge handles this.
Okay, Mr. Van Til, what's your position on that?
No, I disagree.
Okay.
I disagree.
All right. Well, you know, here's the thing. I reviewed the original judgment of divorce, and it does allow for the court to modify spousal support based on a change in circumstances. Ms. Van Til, and frankly, I'm surprised it doesn't contain the language that if you remarry, typically once a party remarries, I mean, that's a change in circumstances that warrants the cessation of payment of spousal support. And the whole idea of spousal support is that you don't have the assistance of your marital partner anymore to support you. And when you get remarried, that's no longer the case. So it really, to me, the only fact here that would be a potential issue is whether or not you were actually married or remarried, I should say. And it sounds like that's not a fact that's in dispute. So for that reason, the court finds that the spousal support should cease.
Boom. Case closed. The judge just delivered a masterclass in family law. She even expressed surprise that the original divorce decree didn't have automatic termination language for remarriage. That's a rookie mistake by whoever drafted it. But here's the key. Even without that specific language, remarriage is such a fundamental change in circumstances that it almost always ends alimony. Mrs. Van Til's attempt to leverage that old $122,000 forgiveness totally backfired. Past generosity doesn't create future obligations, especially when you've literally married someone else. The judge's ruling is exactly what any family law attorney would have predicted. Sometimes the law really is that straightforward.
Cease. And so, Mr. Van Til, you need to file something with the court that indicates that the court is granting your motion. You can use a form like you used to file your motion in this case, okay?
Okay.
But that's an important step for you to follow up on, because until I sign that order, I mean, that's what actually stops your obligation for spousal support. So it's important that you submit that as soon as possible to the clerk's office here in Gaylord.
Okay, so it's the form just like the one I sent for this hearing.
Yep, well, you can find the form in the same place. It's going to be just a blank order. And you're gonna fill in there that the court is granting your motion and spousal support will stop as of February 3rd, okay?
Okay.
Ms. Van Til, did you have any questions about that?
No,
Okay. All right, thank you. That's all for this hearing today. Both parties are free to disconnect at this time.
Thank you.
What a day in court. In our first case, Mr. Bean successfully got his support reduced from $600 to $200 monthly after exposing that his ex-wife had concealed a live-in boyfriend's financial contributions, though that boyfriend's now arrested with no contact order. The judge found middle ground, recognizing both parties' interests in the mortgage property. In case 2, Mr. Van took out exactly what the law prescribes, complete termination of spousal support due to his ex-wife's remarriage, despite her bold attempt to continue collecting $500 monthly after forgiving $122,000 in arrears. Both cases highlight crucial lessons. Always disclose everything to court, understand that remarriage ends alimony, and get everything in writing. If you found these cases as fascinating as we did, smash that like button, drop a comment telling us which case shocked you more, and subscribe with notifications on so you never miss our next courtroom breakdown. What would you have done in these situations? Let us know below.